Well, good morning. Today is March 27th, 2024. This is a follow-up on the demand that was sent to Attorney Goldstein. Of course, the attorney didn't respond to it. And what happened is a quick preview. You could look at the other videos on this. I had to send it out twice to Attorney Goldstein. The first time I sent it out, the United States Postal Service priority with the certified mail. I got the card back, the green card, but it showed in the USPS system as not delivered. So I sent it out again, the package, and it showed it was delivered, but I didn't get the green card back. So, plus I also sent it by email twice to him. What's he going to say? Everything in there was accurate. He can't discuss it, and I'll give you a reason why he can't discuss it towards the end, because I did another minor experiment with a different attorney over something else. So, what happened, he was given 3 days after receipt to respond to it. He didn't respond to it, so therefore he is in default. And this is what I did to show he was in default, and we'll go over it. So how I address this is, at the top it says, in care of Anthony Rubio, and I put the file number of the birth certificate. And then a asterisk after the name, because it's referring to the birth certificate, the address, an email, and then the letter or the notice of default, acquiescence and acceptance is what I call this, is sent to Michael R. Goldstein, Peyton Boland, PL, 3343 West Commercial Boulevard, Suite 100, Fort Lauderdale, Florida, 33309. And then at the top it says notice of default, acquiescence and acceptance. A contract to perform without condition, controversy, or deflection. And here it goes. Having had ample opportunity to respond to the first USPS priority mail certified mail return receipt demand dated February 19th, 2024. Then I listed the certified mail number mailed on February 20th, 2024 with the green card partially signed and dated February 22nd, 2024, then returned to a mere user of State of New York file number 013, the file number of the birth certificate, comma, the demand/package still appears to be MIA physically per USPS website, and noted as suspicious as to why the mail carrier failed to confirm delivery to Peyton Boland, PL. An email with the same information was provided to attorney Michael R. Goldstein on or about February 23, 2024, believing the demand was delivered according to USPS protocol, but not yet entered into the USPS system showing delivery. What's up with this? A second USPS certified mail, and then the number, envelope package, to act in good faith, to remain in honor, and to reincorporate the other certified number of the correspondence in its entirety with the previous demand sent, along with another email sent on or about March 5th, 2024, giving yet another opportunity for Michael R. Goldstein as learned legal counsel to address 12 questions in reference to those citations/information thereto attached to correct or to counter the 8 pages of questions within that document dated February 19, 2024, has been ignored, now believed to be a dishonor, therefore a default. So I think we all kind of remember, you make an offer, it doesn't matter. The cop, the attorney, whatever, you have, I think within 72 hours, in this case I gave him 72 hours to respond, I went the extra 5 miles to accommodate him just in case I never got it, you know, plausible deniability. And he still ignored it. He has to ignore it, by the way, and we'll get into that in a few minutes. To continue on, as learned legal counsel, attorney Michael R. Goldstein, as a possessor of Florida Bar Card 372950 and a representative of the firm Peyton Boland PL, has failed to address substantively, completely, and honestly those 12 questions and related citations provided. Therefore, this notice of default, acquiescence, and acceptance shall provide evidence to the fact you snooze, you lose. And you can see kind of how I did it. You snooze, you lose, right, in capital letters. And the purpose of this is, again, contract was, an offer was made. He didn't respond, he didn't rebut, he didn't counter, he didn't say you're wrong, he didn't do anything, he ignored. And when you send something by certified mail, it's giving them notice. So he's learned legal counsel. He holds, or is a possessor of, a bar card which is issued from a private association, in this case the Florida Bar. And he has what's called an oath of office, not, something of no value that has value. For the simple reason, that's how he makes his money. And technically, I would call him, giving the example of the 14th Amendment, I think it's Section 4, he's referred to, they're entitled to bounties and pensions for insurrection and rebellion against the U.S. Who is the obligor? The United States, not us. We play the obligor or the trustee de suntort, but that's not our role. So as a result, we pay the price. Remember, there is no a way to pay anything. There is only the way to discharge a debt or set off a debt. At least that's to my best of my understanding. And remember, the quote-unquote money is all debt. So to continue on, after you snooze, you lose, whereby attorney Michael R. Goldstein, as representative of the firm Peyton Boland PL and or any other attorney associated with Peyton Boland PL, is contractually obligated to set off, settle, and close any all claims against persons within the River Shores, River Terrace, and River Bend community under the rule of usufruct upon any spoliated, naked owner, an obligee presenting the incontrovertible evidence of facts, namely, and I say a play of words, a state of XX birth certificate to said firm/counsel to either settle the controversy as authorized officers of the court and or forward same to an authorized public trustee with the authorization to set off claims. Highlighted and underlined, it is a fact without further controversy by and through an oath of office to adhere to the law, Michael R. Goldstein, as a possessor of a bar card, agreed to perform under higher claim value as required under the law and without objections to set off claims under the rule of usufruct. You know where this is going to go, right? Attorney Michael R. Goldstein and the firm Peyton Boland PL agreed contractually, without condition, controversy, or deflection, to the following as factually and lawfully accurate to the list of citations and other information provided based upon failure to provide proof of claim otherwise. Number 1, the state of XX, parentheses, any one of the 50 states located within the jurisdiction of the United States, end parentheses, as issuer of a birth record, does actually register people as property of the state and pledges said labor as collateral to fund the operations of the United States. That's a true statement. The United States is a protected purchaser under UCC 8-303. Oh my God. The people's right to their labor was usurped knowingly and intentionally to act as creditor/collateral to support the nation's operations. Whether it is called the Fifth Amendment, parentheses, nor be deprived life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation, end quote, end parentheses, eminent domain, comma, usufruct or subrogation for those not trained in law. The bottom line, the U.S. under a declared national state of emergency, quote unquote, the crucial fact is that the government chose to intervene by taking possession and operating control, comma, or period. By doing so, it became the proprietor and, comma, in the absence of contrary arrangements, comma, was entitled to the benefits and subject to the liabilities which that status involves, end quotes. Attorney Michael R. Goldstein is now placed on notice. There is no consent given to contrary arrangements, even with any attempt to recontract, to ensnare, scheme, conspire, defraud, etc. Period. It is a fact without further controversy that Michael R. Goldstein has agreed without objection. Number 2, the state of XX failed to provide the detailed contractual benefit and liability terms upon the issuance to the one who appears to be the authorized and exclusive known user of said name/birth document or title to public property/registered organization, comma, suggesting trickery, comma, and deception with an attempt to profit off unsuspecting naked or spoliated owners, whereby said obligees make a false claim of ownership or trusteeship to public property, unknowingly accepting the role of trustee de santor. Highlighted and bold. It is a fact without controversy that Michael R. Goldstein has agreed without exception. Number 3, there does not exist any legislative authority to use a name as personal identification. However, stating a name as personal identification is often done based upon a false presumption. Through an act of bad faith, this is yet another form of trickery and deception promoted by social presumption with what appears to be a conspiracy and scheme by those with an oath of office having knowledge to the contrary to not protect the public in violation of said oath of office. Highlight and bold. It is a fact without further controversy that Michael R. Goldstein has agreed without objection. Number 4, as an alternative, if one cannot bring the law, only administrative public policy codes relating to contract performance into court, what to do? Yeah, my writing's not the best. Okay, don't fault me too much. It's a lot of work to do all this. Continuing on, in conjunction with an alternative to usufruct, you now accept an act to set off any claim pursuant to Federal Rules Civil Procedure Number 19, comma, UCC 3-3005, Defenses and Claims and Recoupment, and UCC 3-202, Negotiation subject to rescission to any claim brought by Peyton Bolin to any presumed person and or resident of River Shores, River Bend, and River Terrace community upon receipt of a birth document evidencing the incontrovertible facts. In this specific case, Anthony Rubio, file number 013760, comma, the state of New York shall be a party to any claim presented, suggested, and or threatened in any and all legal matters relating to the person, Anthony Rubio, to set off said claim. It's the law. Infants and minors cannot contract. So the UCC stuff I mentioned is about minors contracting. They can't. Highlighted in bold, it is a fact without further controversy said that Michael Goldstein has agreed without objection. Number 5, the United States still operates under perpetual bankruptcy. The evidence is all around us, all day, every day. It highlighted in bold, it is a fact without further controversy that Michael R. Goldstein has agreed without objection. Number 6, U.S. v. Pee Wee Cole is settled case law. Highlight in bold. It is a fact without further controversy that Michael R. Goldstein has agreed without objection. Number 7, under Senate Resolution N62 submitted by Mr. Shipman, April 17, 1933, states in part, the ultimate, and I'm quoting it, the ultimate ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e., law, amounting to mere user. And use must be in accordance with law and subordinate to the necessities of the state. Bold and highlighted. It is a fact without further controversy that Michael R. Goldstein has agreed without objection. 7A. It is a conflict of interest to compromise an obligee standing in favor of a conspiracy to scheme against unalienable rights to profit and harm by allowing a spoliated owner to play the role of trustee de suntort. Those with the oath of office have a duty to protect unalienable rights, not violate them. God. Are we ready for a drink now? When violated under the current declared national bankruptcy, it amounts to peonage since there exists a lawful remedy under the rule of usufruct. Bold and highlighted. It is a fact without further controversy that Michael R. Goldstein has agreed without objection. Number 8. The original titles of birth of a child are retained by the state of XX and then securitized/monetized. Evidence has been provided to this effect for State of New York file as an example. There is no evidence that there exists available excess interest. There is evidence that there exists available excess interest/funds available to set off claims against the person when a claim is made. Set off reduces the national debt. Discharge increases the national debt. That's my understanding. Highlighted in bold. It is a fact without further controversy that Michael R. Goldstein has agreed without objection. Number 9. See above 4. See 4 above, sorry. Again, highlighted bold. It is a fact, blah, blah, blah. Number 10. An attorney having learned legal knowledge has a duty to provide honest services in regard to sending out offers to contract by USPS mail and receiving certified mail in return. Highlighted bold. It is a fact without further controversy that Michael R. Goldstein has agreed without objection. Yeah, good luck. Number 11. Since the one who is issued the birth document receives a certified copy of the document and not the original, this incontrovertible evidence of facts provides evidence to the fact the birth document is usufruct compliant, and the one it was issued to is entitled to equitable relief to set off any and all claims within the jurisdiction of the United States for the pledge, seizure, and usurpation of one's unalienable rights to one's own labor for the purpose of collateralization to fund the United States, a nation, and its operations. Oh, did I word that right? Let's see. For pledge and of one's for the purpose. Okay, no, that's good enough. Highlighted, underlined. It is a fact without further controversy that Michael blah, blah, blah. 12. in the ex officio duty of public officers